Are we on, Barb? Okay. Welcome to the meeting of the Travel, Recreation, Wildlife, and Cultural Resources Committee. I guess we will get started because we have a long agenda today. So if you will take the roll, Barb, that would be great.
Representative Angelos? Here. Representative Burkhart?
Here.
Representative Byron?
Excused.
I know he was here, though. Representative Larson?
Here.
Representative Singh?
Excused.
Representative Storer?
Excused.
Vice Chairman Western?
Excused.
Representative Winter?
Here.
Chairwoman Newsom?
Here.
Thank you. And I'll mark them in as they arrive.
Okay, that'll be great. Thank you. So we'll start. First, I kind of want to set the ground rules, and we're always supposed to have this little speech about civility and all that. And my little speech is be nice or leave. So if you can't do that, then we'll ask you to leave. But as we go here, because we have 5 bills to get through, so the initial sponsor of the bill will have 10 minutes. And then each successive commenter will have 3 minutes, and I think that'll keep us rolling as we go. I'm hoping my good, I was supposed to have an intern, but I don't. Oh, okay, so you're my timer? Great. Okay, so I have a timer, so we will start. So Senator Driscoll.
Madam Chairwoman, committee members, thank you for the opportunity to present Senate File 125, pari-mutuel wagering activities amendments. Folks, if you remember last year, I kept a bill that was fairly important in my drawer because we could not get the FBI to come back to us on what they wanted. This is a cleanup bill to get it where our background checks and fingerprinting are in line for our pari-mutuel activities with the FBI. Over the interim, your good chairman, the chairman on the Senate side, and a number of us got together. We got the language in line with what the FBI wanted to see, and that's what you see in front of you. It has all the definitions and the language. The only change that's come from the bill, exactly as it's been done, and the bill has been approved by the FBI at this point, is on page 3, lines 17, 18, and 19. Says the commission shall require all permittees, licensees, current prospective employees. We changed the shall to may. That was to allow for some slack in some of the pari-mutuel events that have gone on in the past, which is tie down steer roping and some of the rodeo events that may come, and probably the Indian relay races. They really do not do background checks and do some of the rules. So that allows that, but that's really all this bill does. We've tried to keep it as clean as we can, unamended, because it's really is at the request of the FBI. This is so, if we lose this bill, there's a good chance you could be in a bind running your horse station during the summertime. With that, I'd stand for any questions.
Any questions for the president? Seeing none. Thank you.
Thank you.
Director Moore, would you like to comment?
Thank you, Chairman Newsom. My name's Charlie Moore. I'm the Director of the Wyoming Gaming Commission. Appreciate you having me here today. As President Driscoll had mentioned, we'd worked on this all summer and spent a lot of time on this. But I'd like to leave you with one point. There's no fiscal impact, and that's for a reason, because this does not change anything that we're doing. There's no additional lift, because there is no additional lift to this. It is codifying what the FBI wants in statutes to continue to do the work we're doing. So any other comments? I'll take questions, whatever you'd like, Chairman.
Questions for Director Moore? Hearing none. Thank you, Director.
Thank you.
Any public comment on this? Any other agencies or anyone in the public? Seeing none, we will close public comment. What's the feeling of the board?
Move the bill.
Move the bill. Moved by Larson, seconded by Burkhart. Any discussion on the bill?
Question.
Any amendments? Hearing the question called, we'll go ahead and take roll. Thank you.
Representative Angelos?
Aye.
Representative Burkhart?
Aye.
Representative Byron?
Aye.
Representative Larson?
Aye.
Representative Singh,
Excused.
Representative Storer,
Aye.
Vice Chairman Western,
Excused.
Representative Winter,
Aye.
Chairwoman Newsom.
Aye.
7 aye, 2 excused.
Great. So we'll move that forward onto the floor. Thank you. Thank you, Director Moore, for making the trek down from Casper. I appreciate it. Next on our agenda is Senate File 118. Senator Hicks is here to do his bill. And yeah, if the Game and Fish would come up, that would be great. So we're on the same time, 10 minutes to present and then 3-minute comments. Thanks. Senator Hicks. Oh, is your mic on?
Bighorn and domestic sheep relocation federal action. Just a real brief history on this is a genesis that started in the 1990s due to intermingling of bighorn sheep and domestic sheep in other states. And as a result of that, some of the federal agencies started eliminating domestic sheep grazing allotments. In 2000, then Governor Geringer and senior U.S. Senator Craig Thomas convened a working group here in Wyoming to address this issue and try to come up with a collaborative solution. In 2004, that group, which is made up of the state agencies, nonprofit wildlife organizations, and the federal agencies, it's a broad collaborative group that's been working on this issue. In 2004, they generated a plan that has become now known as the Wyoming Bighorn Domestic Sheep Working Plan. Under that plan, a number of reintroductions of bighorn sheep have occurred in the Bighorn Mountains and the Devil's Mountain, or the Devil's Canyon herd. I don't know if that's the exact designation, Ferris Seminoles. But we have avoided many of the consequences and circumstances of federal legislation and action of removing domestic sheep and livestock reductions and grazing associated with that plan. So that started in 2004. The legislature codified that plan in 2015 to give it higher deference in any federal decision-making. You know, our statutes will trump an agency's policy or an agency plan. And so that plan has been working in the state of Wyoming. We do have bighorn sheep that are on BLM lands associated with introduction pursuant to that plan. So, Madam Chairman, we are in the process and have been working for a number of years as a state and through this collaborative bighorn sheep, domestic sheep working group, looking at trying to reintroduce sheep into the Sweetwater Rocks area of Wyoming. We've run into some issues again with the federal government, in particular federal rules and regulations under BLM guidelines 1780. So what we're trying to do is pave a way that we've used this similar type of legislation on the Medicine Bow National Forest Plan, Bighorn Sheep Plan. So we've had similar type of legislation in the past that's curtailed the federal government for taking any contrary action associated with domestic livestock where we have bighorn sheep. So I'll just walk you through the bill, Madam Chairman. Page 2 just goes into some legislative findings that highlights much of what I just discussed with you. Goes on to page 3. I think the important point here is if any removal, because this would require removal if any of these are triggered, any removal of bighorn sheep from the Sweetwater Rocks Cooperative Review Area would be attributed, number A, onerous federal regulations that unduly impedes the state of Wyoming's ability to manage wildlife and domestic livestock grazing in conformance with that plan. It was adopted in 2004 and codified in 2015. Other reason that would potentially result in removal of those sheep would be third-party litigation designated to use bighorn sheep as a means of eliminating domestic livestock grazing on BLM-administered lands. So, Madam Chairman, and we go into the subsection B, and we go over to 4, and this is all in conformance with what we're trying to do here. This is the trigger provision. So in conformance with the plan, it would require the department shall relocate or remove all bighorn sheep from the cooperative review area if any federal judicial action or federal agency action requires or could require. So those requirements that would trigger a potential removal of sheep, if and when they're introduced, it would result in a federal action that either eliminated or suspended a domestic sheep grazing allotment or any changes to the United States BLM Resource Management Plan, grazing allotment, or grazing agreements due to the presence of bighorn sheep in the Sweetwater Rocks. So that's the trigger. If there's any significant federal action that jeopardizes livestock grazing on those allotments, if we introduce sheep back in there, the duty would be, because of those issues, that we'd have to remove those. It's a preemptive component to try to discourage the federal agencies from taking any action that would have adverse impacts to either the permittee or the bighorn sheep population. Madam Chairman, just goes into subsection C. That just provides us the relocation timing. That timing would be triggered, associated with the Wyoming Department of Agriculture would make a finding that the federal government or a third-party interest triggered an action to reduce livestock grazing. Once that's certified by the by the Department of Agriculture to the governor, he would notify the Game and Fish Department to start removing bighorn sheep associated with these federal actions or third-party litigations. So, Madam Chairman, if we just flip over to page 6, this just brings in some of the existing policies that we currently operate under and codifies some of the stuff that the department does. So when bighorn sheep under F stray outside of an existing herd unit, they have a policy to remove those bighorn sheep. It does also, when we get in here, this is the provision where we get into 6 where it triggers that judicial action that the governor then would make a determination to file against the federal government. So if the federal government did something that was inconsistent with Wyoming's plan and didn't follow federal law, it would trigger a lawsuit by the state of Wyoming. The next component under subsection J is the Attorney General, again, shall file an action against the federal agency to stop an enforcement or administration in there. So there's 2 potential actions the state would take in lieu of once we start removing those sheep. And again, if it was due to a federal action or third-party litigation, if it was a violation of state law or not in conformance with our plan, we would try to intervene or file a lawsuit for an injunction in federal court until we could get this resolved. So, Madam Chairman, that gets us to page 7. This just provides funding. When we go into page 7, and then section 3 on the next page provides an additional $100,000 to the Wyoming Livestock Disease Research Partnership account. That money would be utilized by the department for surveillance, testing, tracking bighorn sheep, and in the event that the worst case scenario, there was a removal, they could utilize that money for the removal. It also provides a $50,000 appropriation to the Wyoming Department of Agriculture to assist those permittees up there to do all the rangeland monitoring, everything necessary to comply with the terms and conditions of their grazing permits through the Department of Agriculture. With that, Madam Chairman, I'd stand for any questions.
Any questions for Senator Hicks? Representative Burkhart.
Thank you, Madam Chairman. Excuse me, Senator, I see that we talk a lot about the Sweetwater Rocks Cooperative Review or area, but I don't see a definition of what that is in the bill. Is that my oversight?
So,
Senator Hicks.
Madam Chairman, Representative Burkhart, I think the department will address that, but if we reference the Wyoming Bighorn Sheep Domestic Plan, it designates what a cooperative view is, a non-emphasis herd, a different herd. All those definitions are already in statutes codified in that plan.
Okay, follow up, Madam Chairman. So, Senator Hicks, looking at the area, and I'm familiar with this area, how do the landowners feel about this?
So,
Senator
Madam
Hicks.
Chairman, specific to that question, I would say it's mixed. There's some that are very favorable to this. There's some that have some concerns, and because of those concerns, that's why you have this legislation before you today, is to try to alleviate those concerns. Any adverse impact associated with those private lands or federal permits associated with this, particularly the federal grazing permits, would trigger removal of those bighorn sheep. So the essence is there's no threat if there's no sheep. That's what the bill does, is afford those protections to those permittees on those federal lands.
Follow up?
I'm good, thank you.
Any other questions? Representative Winter?
Yes, thank you, Madam Chairman. Senator Hicks, is just a straightforward question. Are there any sheep in the Sweetwater Rocks at this time? Do you know?
Senator Hicks?
I'm probably not the one to testify to that. I would call a friend on that.
Any follow-up? We're good, okay. So I guess the Game and Fish, you're up next.
Thank
You
you,
want to
Madam
introduce
Chair.
yourself? And
Thank you, Madam Chair and members of the committee. Brian Nesvik, Director of the Wyoming Game and Fish Department. I don't have a lot to add to what Senator Hicks has, but I do have a few key points. To answer Representative Winter's question, if I may, to our knowledge, there's no documented bighorn sheep in this area that is contemplated in this bill. There are sheep close to the south in the Ferris-Semino herd, but we don't have any documented north of the highway. In the past, there have been some foraying sheep that have moved all over the state, actually, and when we have those sheep that are outside of where they're supposed to be, we go and remove them, and we have a handful of those each year. To Representative Burkhart's question, and we're going to bring an amendment to make this more specific. And I think all of you have a copy of that. I can talk about that when you start working the bill, but it will be to further define that, Representative Burkhart, so that it's specific to the actual Sweetwater Rocks herd unit. And that's also defined in department documents. It's within that cooperative review area. It's a smaller area, so. Madam Chair, I'll just, a couple quick things. So first, I would point out that this bill aligns with a letter that I issued 3 or 4 years ago to the BLM that advised the BLM that if we were to reintroduce bighorn sheep, that we would remove sheep if they took any federal actions that in any way used bighorn sheep as a talisman to reduce grazing opportunities, change standards and guidelines, alter grazing permits, et cetera, et cetera. And so this bill does align with the position that the department's had on this issue for many years. We received a request in accordance with the Wyoming plan, a request from one of the landowners in this area to reintroduce sheep. They were interested in having them. And the commission's been contemplating that for 3 or 4 years now and has been at loggerheads because of the issues that this bill addresses. So this bill addresses a lot of those hurdles and roadblocks that have been in the way to being able to reintroduce bighorn sheep here. This bill, with that said, what it does not do, it does not direct the department to reintroduce sheep into the bighorn or into the Sweetwater Rocks. It provides a tool and it provides assurances that so that if the commission does make that decision, that those assurances would be in place before the sheep were reintroduced. With that said, there is always a potential that, you know, groups of sheep, they're fairly close, could move into this area before we transplanted them. These would be assurances that are not in place now that would be even without a reintroduction if sheep made it there on their own. This is really, as the good majority floor leader outlined, this is about providing durable, predictable solutions for domestic livestock producers in this area. And with that, I would stand for any questions.
any questions for Director Nesvik? Representative Winter?
Yes, thank you, Madam Chairman. Director, have there been any problems with the area south of the Ferris Mountains there, like on the Buzzard or the several sheep outfits on that side of the mountain? I just wondered if there had ever been any problems in the past.
Director Nesvik?
Madam Chair, Representative Winter, the short answer to that is no. We've had sheep there for a number of years now, and we've had no livestock conflicts that weren't. We haven't had any livestock conflicts in the immediate area. There have been some foraying sheep that might have come from there. We can't always tell, but we've been able to resolve those quickly by removing those sheep.
Any other questions for the director? Thank you for that explanation. Is that it for you guys? Okay, stay close, because I think we'll have some questions. So we'll open it to public comment. So just to be clear, you have 3 minutes.
Got it.
Okay.
All right, good morning, Madam Chairwoman Newsom, members of the committee. My name is Katie Cheesebro. I'm the Executive Director of the Wyoming Wild Sheep Foundation. The Wyoming Wild Sheep Foundation is an original signatory to the Wyoming Plan, which Senator Hicks mentioned is codified into law and mandates that the cooperation of wildlife advocates and the agricultural community to cooperatively manage bighorn and domestic sheep in the state. Additionally, we have been a member of the Wyoming statewide domestic bighorn sheep interaction working group for over 20 years. As such, we are committed to working with our agricultural partners towards the interaction working group's goal of maintaining healthy bighorn sheep populations while sustaining an economically viable domestic sheep industry. We feel this bill meets the interaction working group's goal by providing legally defensible protections to federal grazing permittees in the Sweetwater Rocks area that could potentially be affected should bighorn sheep be reintroduced or should they naturally migrate to the area. This bill is a good faith effort to protect our agricultural partners and create a landscape that fosters the coexistence of agriculture and wildlife into the future in Wyoming. As such, the Wyoming Wild Sheep Foundation, this bill also creates a framework for a Wyoming solution to a Wyoming issue that considers the needs of both agriculture and wildlife. I think also to keep in mind, I think you'll hear a little bit of opposition from some wildlife advocates in this, and keep in mind that those groups haven't been in the room for these interaction working group meetings for the past 20 years. These are things that have been discussed by the agricultural partners, by the wild sheep advocates for years. And this is a solution that, our ag folks have requested, and this is what we've come up with. And we're eager to keep this solution at a state level. So as such, the Wyoming Wild Sheep Foundation stands in support of this bill, and we ask your favorable consideration and support. With that, I'll stand for any questions.
Thank you, Ms. Cheeseborough. Any questions for Ms. Cheeseborough? No, thank you so much.
Thank you.
Ms. King, welcome.
Thank you, Madam Chairwoman. 3 minutes. Sabrina King. I'm here today representing the Wyoming chapter of Backcountry Hunters and Anglers, and we are opposed to this bill. And the previous speaker was right. We have not been in the room for those conversations, and there are a lot of people who have not been in the room for those conversations. That working group is a select number of people, and I will say that there are folks in that working group who have come to me, we're not even in that working group, and said that they do not support this bill. There are amendments that were put on in third reading to this bill that were not discussed by that group, that came from one stakeholder from that group. So the notion that because we have not been involved for the past 20 years in a very specific working group, we shouldn't have opinions on this bill, I disagree with strongly. I don't have time in these 3 minutes to go through all of our objections, but I will say that there are 2 amendments that we would ask this committee to put on this bill that would move us to a neutral position. The first one of which is on page 2, line 9. The original draft of this bill, after conservation, read conservation, protection, and expansion. We would ask this committee strike and maintenance and reinsert protection and expansion. This is setting the policy of the state of Wyoming when it comes to bighorn sheep, and it is our belief that it should be the policy of the state of Wyoming that we conserve, protect, and expand our bighorn sheep populations, not to maintain our bighorn sheep populations. The second amendment that we would ask for, and this actually brings us in line with what has happened in the past when we have done this, is on page 4, line 9. After any, insert final. So it would read area if any final federal judicial action or federal agency action requires, and then strike or could require the following. Because as this bill is written right now, any potential federal action that could potentially mean that at some point in time in the future there's an impact on domestic sheep population, we're automatically removing the sheep. We have not done that before. Previous legislation that was brought in 2013 and 2015 required final federal action to trigger the removal of sheep. What we're doing here is we're setting up a scenario in which maybe something is proposed, a rule or a regulation, Game and Fish is then required to remove those sheep. Maybe that rule doesn't actually go into place because it's either enjoined or it's struck down. You're then putting the sheep back on. We're yanking the sheep back and forth. It should be a final federal action. If you look at what we have done in the past, that has been the language that we have had in the past. Those 2 amendments We disagree with this bill and we disagree with the premise of inserting this amount of politics into our green books, especially when it comes to wildlife management. But with those two amendments, we could at least live with it. So I would ask the committee to consider those amendments. I don't think they make significant changes to the bill. Hopefully people can live with those, but it should be the policy that we expand our bighorn sheep, and it should absolutely be the case that we do not remove those sheep until there is final federal action. And with that, I will stand for any questions. Thank you, Madam Chair.
Thank you, Ms. King. Any questions for Ms. King? No. Thank you for your testimony. Ms. Johnson, please introduce yourself.
Madam Chair, members of the committee, Jess Johnson, Wyoming Wildlife Federation. I'll keep it pretty brief as I feel a couple before me have touched on issues. We do stand in support of this bill. We have also been a member of this working group for, I think, we've had a seat at the table at least for the 20 years. It's gone between my executive director, myself, and people before me for certain. So I'm newer to sitting here. These are public and open meetings. They are not closed door. Anybody can come. Very often, a lot of folks are in the room weighing in on both sides. And it has been, I would say, contentious at times. And a lot of that is us reaching across the table and figuring out a way forward and finding that compromise. I think there's a hearty thank you to our director and for the letter that he wrote, essentially saying exactly what this bill is bringing forward that they were willing to do. This is just putting it in statute. I think the other thing that I always want to bring forward is that our wild sheep management is actually in state statute. This is not setting precedent in that. This is just sort of helping on how we expand that so that we make sure that our ag partners are at the table. We are find very, very high value in the open working lands. You know, if it is not open and working lands, there is no place for wildlife in this state. And so we do recognize the importance of this. And I do think this is a new approach. The times have changed. Things are different now. And you know, what ranching was 20 years ago, I come from a ranch family, is different from today. What ranching was 40 years ago is different from today. So as these things change, so must we. And we see this as a really good across the table reach out to agriculture. We will keep working with them. You know, I think everybody wants to see more bighorn sheep in the state, and we also want to see agriculture in the state. Those two can exist together, and I do think that this is a very good compromise on both sides for this. So thank you for your time. I'm happy to answer any questions.
Any questions for Ms. Johnson? Thanks. Any other public comment? Are we doing good on the 3-minute thing? Right. Does your phone alarm? All right.
Okay,
Great.
thank you,
Thank
Madam
you.
Chair. I'm Ken Hamilton with the Wyoming Farm Bureau Federation. Our organization opposes this bill. And the reason for it, and I think the good senator mentioned it, we've got landowners in that area that are concerned about what this will bring to them, what the impacts will be to their federal grazing. I think that's brought out on page 5, subsection E, where it says that the state and its agencies shall coordinate and assist Wyoming congressional delegation in pursuing change to federal law, rules and policies in order to bring them into conformance with the Wyoming Bighorn Domestic Sheep Plan. But the question you have to ask is what happens if the federal government doesn't do that? And that's where our members are concerned, is that they're concerned that the federal government, who has routinely ignored some of Wyoming's laws, can come in here and make some arbitrary changes. And yes, we would then sue them. But at some point, you gotta roll the dice and wonder if we would win in a court of law. So I would suggest that if this legislation would be going forward, that we add an amendment to subsection E that just says no reintroduction efforts shall occur until federal legislation is brought into conformance with state law. And the reason I say that is because if we take this and we go forward with reintroduction, even though we haven't got this guarantee, we jeopardize those producers that are in that area right now. I think one of the questions maybe, and I heard it a different way, was how many sheep are in that. If you have domestic sheep in that area, you run the risk, and there's a number of sheep producers that have testified to this, of having their permits changed or altered in conformance with bighorn sheep. And we've seen it done in this state, where even where there weren't any sheep, there was a requirement that the Forest Service, or request that the Forest Service put restrictions on permits to protect bighorn sheep habitat. And that's what we're dealing with the federal government here. The federal government hasn't played in this arena, and I've been part of this working group since its inception. But the federal government has just said, we can't join in any agreements because we understand that federal law may tell us to do something different. So that's part of the reason that our folks are concerned about this. We don't feel that, we feel a little bit like this is maybe the cart before the horse. Federal guarantees should occur, and then we can go forward. And I totally agree that the wildlife advocates have been very, very helpful in working with the state of Wyoming. I think they've really come forward and said, we want to protect agriculture. But ultimately, the big player in this is the federal government. And without their participation, we really are somewhat getting the cart before the horse. Thank you, and I'd be happy to answer any questions.
Thank you, Mr. Hamilton. Any questions? I have just one thing. If you could restate your amendment, that would be helpful.
Madam Chairman, I apologize because I was just trying to come up with something that would be helpful. But under page 5, subsection E, we would add a section that said reintroduction efforts will not occur until federal legislation brings it into conformance with the Wyoming Bighorn Domestic Sheep Plan. Created under WS 11-19-604.
Can you state the statute number again?
I'm sorry?
Can you state the statute number
Oh,
again?
yeah, it's the same statute that's in the previous sentence there. It's WS 11-19.
Oh, 19-604.
Yeah.
Great, thank you. Questions? No, thank you for your testimony, Mr. Hamilton. Further public testimony?
Thank you, Madam Chairman. Keith Kennedy for the Wyoming Wool Growers Association, and I'm here to exhibit Ag Unity with this amendment that we've proposed for your adoption. We would support the bill, and we deeply appreciate the third reading amendment that the sponsor of the bill brought on the other side of the House. Many of the concerns that we have are those that the previous speaker mentioned, and we would prefer to keep the same language in as far as cooperative review area, Madam Chairman. We feel like that language doesn't presuppose that bighorn sheep will establish in this area if they are relocated there. And with that, I would welcome your questions.
Thank you. Any questions? Hearing none, thank you for your testimony. Anyone else in the room want to testify? I think we have a couple online. Oh, if you're online and want to speak to SF 118 bighorn sheep, please raise your hand. Did you want to talk? Okay. We have one more and then we'll get our online people ready. Hi.
Howdy, Madam Chairman, members of the committee. I am Matt Hubler. I am one of the co-authors of the letter seeking the reintroduction for the Sweetwater Rocks 3 years ago. I'm going to use my 3 minutes on a reading about conservation from 1935. There's two ways to apply conservation to land. One is to superimpose some particular practice on the pre-existing system of land use without regard to how it fits or what it does to or for other interests involved. The other is to reorganize, to gear up the farming, forestry, game cropping, erosion control, scenery, or whatever values may be involved so that they collectively compromise a harmonious, balanced system of land use. The farmer's still trying to make out what it is that the many-voiced public wants them to do. The administrator, who is seldom trained in more than one of the dozen special fields of skill comprising conservation, is growing gray trying to shoulder his new and incredibly varied burdens. The stage, in short, is all set for somebody to show that each of the various public interests in land is better off when all cooperate than when all compete with each other. Aldo Leopold wrote those words, and in the 90-year since, just as we discussed today, a bill seeking to govern cooperation between the domestic livestock producer, the administrator, and the many-voiced public. For cooperation, I know the pound of flesh given by the bighorn sheep interests is in this bill. Since the only way wild sheep can apparently endure in the Sweetwater Rocks is if the federal government, or the administrator in this case, does their part in solidifying a positive accord with past and future uses. Furthering legislation in the name of agriculture and bighorn sheep at the state level codifies that cooperation and lessens the reliance on the federal government to make those decisions. I'm asking you to move this bill out of committee as written to further this co-action in Wyoming. Thank you.
Thank you, Mr. Hubler. Any questions? No, thank you so much. Any online yet? Anybody with their hand up online? Yes. Okay. Urbicite. Ms. Urbicite, welcome.
Good afternoon, Madam Chairwoman and committee members. I'm Kat Urbicite. I'm the Vice President of Wyoming Wool Growers Association. And I just want to point out that this issue isn't about public lands livestock producers being opposed to bighorn sheep. It's about the current federal policy that requires restrictions on our grazing permits when bighorn sheep are present really anywhere in the vicinity of our grazing allotments. So the purpose of the bill is to take the burden from livestock producers for the risk of contact between bighorn sheep and domestic livestock, to take the burden of that off of livestock producers and to transfer that to the state. Director Nesbitt told you that his agency has no interest or intent to impact domestic livestock grazing in the area. He's pledged that should a reintroduction of bighorn sheep move forward and then be used as an instrument to negatively impact the livestock grazing, the department would remove the bighorn sheep. This bill puts that pledge into the statute. And if the BLM were to alter its policy to allow state wildlife agencies to accept the risk and responsibility for bighorn sheep management near domestic sheep allotments, we wouldn't even need this bill. But if bighorn sheep were to be transplanted into the Sweetwater Rocks today, anti-grazing advocates could file a lawsuit to restrict livestock grazing, as they have pledged to do with any of our domestic sheep permits. And it's not just domestic sheep. One organization has already requested that the Shoshone National Forest prohibit any cattle grazing within 22 miles of bighorn sheep habitat. So the passage of this bill with the revisions that I emailed to you would pose a significant impediment to that kind of action that is really prioritizing ridding the rangelands of livestock over the opportunity to expand bighorn sheep populations. Thanks so much for giving me the time to speak with you today, and I'd be happy to answer any questions.
Any questions for Ms. Urbicite? So I guess I have a question for Keith. And, or the amendment that you brought from Wyoming Wool Growers, is that the same one she's referring to? Okay, thank you. Because we have all pages of amendments, so we didn't want yet another page. Thank you. Any questions? Nope, okay. Thank you so much for your testimony. Any other people online? Okay. Any other people in the room want to comment on this? Okay, I think we'll go back to Director Nesvik, if you could describe your amendment.
Yeah, Madam Chair, so basically on page 2.
Is this the one that starts with Senate File 118 in bold?
Yes,
That's
that's the amendment right there. And essentially what it does is it replaces the cooperative, Sweetwater Rocks Cooperative Review Area with the Sweetwater Rocks herd unit, and then, executes that throughout the bill to make the rest of the bill conform with that language. And again, to describe the issue, we currently have a population of bighorn sheep, the Ferris Seminole population, in a separate herd unit that is really, it's in the same cooperative review area. This amendment is necessary to ensure that this bill focuses on the area that we're trying to focus on, which is the area, the Sweetwater Rocks herd unit. So I would recommend that the committee consider that amendment.
Any questions about this amendment? Representative Larson.
Thank you, Madam Chairwoman. I kind of have a question on all of the amendments that have been presented for both of them, if that's okay. So, I mean, all of the amendments presented, it seems like there's some disagreement on how this should go forward. How would you see the implementation of these amendments outside of yours go into this bill? And I mean, I guess that's for either one of you, so.
Senator Hicks.
So, Madam Chairman, I think that many of these could be worked into the bill. There's a couple of them that are just poison pills. The one suggestion that we just wait till the federal government to act is a poison pill. It negates the purpose of even having a state policy or a plan. We're just going to wait for the federal government to determine what the fate of livestock grazing and bighorn sheep is in the state of Wyoming. So I don't think that's something that ought to be considered, and I don't think it's consistent with the spirit of the cooperative nature that the bighorn domestic sheep is working on. So that would be one. Many of the suggestions that were proposed by the wool growers, I think that can be worked into this. There's still some language on a couple of those that I don't think addresses what they intend to do, which some of that language on page 4, line 19, page 4, line 20, and then page 6, line 6, actually expands the potential changes by the Bureau into the Ferris Seminole herd unit. And so this is supposed to be specific to the Sweetwater Rocks. The way that's worded, I think it's just, I don't think it was intentional by any means. We just need to get that wording right. The rest of their proposed amendment, I think we can work in. The only other change that I would say to that would be that when we get to that new language that they strike out, I think we ought to leave that language on page 2, lines 17 through 21, and then bring in their language in a new Romanet number 2. So we're going to include that into the bill. And that gets to the hold harmless provision. I think it is the state's property. As wildlife, is in our statute says it belongs to the state of Wyoming, and we ought to assume some liability associated for that property if it damages somebody else. But I would be reluctant to just strike that language in 1721. I think that's important for all the parties, the other side of the issues out there, that we recognize the plan has worked in places, and bring that language in. And it would require a little bit additional language in there to do that. I've got that, Madam Chairman, if you'd like. But the rest of their provisions on everything on line 3, line 4, except for the line 419 and page 4, line 20, and then the page 6, everything else could be brought in, and I think it's just clarification in the bill.
So what page 6 things are,
So on
would you like to address?
On page 6, where it says line 6, strike, I think you have to leave that out. Again, I think it's an unintended consequence that the way that's worded, that would expand this into the Ferris Seminole herd. And I just think it's a clarification we need to work on, maybe a committee of the whole or a second reading amendment to work with the sponsors of that to make sure what we're trying to do here, the way it's worded now, it expands this into a different herd unit. That's not the intent of this legislation.
Okay. Any questions about that? Thank you. So I think we'd have 2 pages of amendments and then some other suggested amendments by some other folks. So I guess as we work the bill, we'll work through those, so. No further, I'm going to close public comment, and we'll come to the committee. What's your pleasure? Moved by Representative Andrew and seconded by Western. Okay, I guess we can look at the Game and Fish amendments.
Madam Chair,
Representative Larson.
I'd like to move the Game and Fish amendment as presented.
Okay, any moved and seconded to adopt the Game and Fish amendment as presented? Any discussion on that? Okay, we'll vote. All those in favor say aye.
Aye.
All those opposed? All right, moving on, we have the Wool Growers Amendment. Keith, would you want to come up? So I guess as Senator Hicks talked about it, the first line on page 2 suggests striking all of this language, and Senator Hicks suggested making a Romanet 2 after the Romanet 1. Are you good with that? Okay. So we would, on page 2, on line 22, we would add a Romanet 2 and add that language. Is that good?
Yes. Yes, Madam Chairman.
Barb, that makes sense? Okay. Then the rest of those amendment from, on page 3 and on page 4 up to line 19, are we good with those? Committee?
Madam Chair,
It's Representative Larson.
I think we can go ahead and, I mean, would you like me to just move these? So we'll do the language with paragraph 2 on page 2. So I'll move that, as well as page 3, line 21, page 3, line 22, page 4, line 8, page 4, line 12, page 4, line 13, page 4, line 17. I will not include the page 4, line 19 or line 20. I will include page 5, line 15, page 5, line 21, page 6, line 5. I will exclude page 6, line 6, and then include page 6, line 19, page 9, line 2, and page 9, line 3.
Do I have a second? Representative Larson moved and Representative Angelos seconded.
Madam Chairman,
Senator Hicks.
so just because of the drafting construct, I think when you get down to the page 6, line 18, it says after A, insert B. So A is just legislative findings.
Okay.
And so that probably, and this is a technical or a correction, it should have been B all along. But I don't think we can have a trigger as far as associated with any potential legal action by the state associated with a legislative. It doesn't hurt to leave it in there. You could do A and B, but I don't know that that would ever trigger because of a legislative finding, because it's not really a statutory construct. It's illegal. It just says this is what we find as the legislature. It doesn't hurt to leave it in there. But
Okay.
it would be A and B. So I think the language is fine.
Okay.
May be redundant, but it's fine.
All right. What's the feeling of the group on that? I think we'll leave it. Okay, any other comments on the amendment as presented?
Question?
Calling for the question. All those in favor say aye.
Aye.
Opposed, no. Okay, that portion passes. Then I think we should maybe address those other portions of this amendment. Line 4, page 4, line 19.
Madam Chairman, can I make a suggestion?
Absolutely, Senator.
Madam Chairman, on those two provisions, I would leave the language that it is now. Let's get with again, back to the collaborative partnership and sit down with all those and make sure that we agree on what the language actually does.
All right, so
And then maybe somebody on the committee, the co-sponsor, could bring that as a committee of the whole or a second reading amendment.
Okay, so you and the director and the wool growers will get together and hash that out.
Yeah.
Perfect.
Wild sheep, anybody that wants to sit in on that discussion is more than, and again, back to the collaborative nature, anybody that wants to sit in on that, I think myself and Representative Western could facilitate that to happen.
Okay. Then we did have another suggestion from the Backcountry Hunters and Anglers on page 2, line 9 to, let me see, I think it was suggested that the original language in the original bill, the not engrossed bill, on that page had conservation, protection, and expansion,
Madam Chairman,
and not
if I may,
maintenance. Yes.
I think it's contemplated when we talk about the conservation of wild sheep that includes expansion. It's not
Okay.
explicit, but, I think it's implied
Okay.
through the term conservation of bighorn sheep.
Would the committee like to make it explicit? What's Representative Western?
Thank you, Madam Chairman. Just speaking on behalf of myself, I think the way we've got it in the engrossed version is probably adequate. I mean, we want to take this thing one step at a time, and this project is a big step, and so let's just kind of keep it on the here and now and the project pending before us, but that's just my opinion.
Okay, so any other comments, questions? So there's no proposed amendment there? All right. The other suggestion was on page 4, line 9, to add final federal judicial action. Senator, would you like to comment on that? Any amendment? Representative Storer?
I just would like to understand that amendment. I didn't catch
So,
the actual language there.
so Madam Chairman, here's the potential scenario that a final federal action can always be appealed in the court system, and it can drag out for a number of years. And so if we leave it with the final federal judicial action, and then the action's appealed, it would result in potential harm to those domestic livestock grazers out there. And so it's really a judgment call on that issue, but my concern is that if we say a final decision and then that decision's appealed, you may end up resulting in some reduction or some negative impact to domestic livestock while all this is working its way through the court system. And then you have to reverse that. In the meantime, all that damage and that economic hardship to those producers has occurred. And so the presenter was correct. In the other cases, we've used similar language twice, but those were reactive to circumstances. There was a lawsuit filed by an environmental organization against the Forest Service, and so we reacted to that. This is basically to set in policy that this will be going forward a preemptive. It says we're not going to let you go in there and damage domestic livestock producers associated with this. So in this particular case, I think to meet the spirit of what we're trying to do is provide those permittees and those people's livelihoods reassurances that if the federal government does this, we don't have to wait till they've already been damaged to start the potential removal or relocation of those bighorn sheep. So it's a policy issue, but I think my concerns is in the past we were reacting. This time we're trying to be proactive and create a win-win situation. That those folks that are livestock raisers have those afforded those protections that are in place before any of this happens. That also paves the way for potential reintroduction into the future. So that's the nuanced differences between the other legislation and what this does as it contemplates now.
So what's the feeling of the committee? The Representative Storer?
Thank you. Just as a follow-up, I guess I would like to move the amendment in that same question, in that same sentence, or could require to delete that language. Just because it seems like that's an action, it's requiring an action based on a hypothetical. And the hypothetical is an unknown. And, any federal action could require anything in the future. So it just doesn't really make sense to include those three words there. I think I understand what Senator Hicks is saying about the use of the word final, but
So Madam Chairman, if I may.
Senator Hicks?
The federal government can't, and we all know this, just can't take, or supposedly take any just arbitrary or capricious actions. So that they would have to initiate some type of action, usually NEPA, to start reducing domestic livestock or stuff. That takes a little bit of time. You know, once they publish in the Federal Register that they're going to review this, or they go through an allotment management plan review, it's still a NEPA-related action. So I think it's appropriate. It is a federal action once they start that process.
Okay.
I don't know if that answered, Madam Chairman, Representative Storr's question or not.
Representative Storr?
perhaps another option might be to say, if federal judicial action or federal agency action requires or indicates that it may require. I just feel like could require is just pie in the sky. They could require anything, anytime down the road with that language.
Can you point to the exact line? Madam
This is
Chair?
line 10, page 4 in the engrossed copy.
It's 10 on page 4.
Senator?
It could go either
Either way,
way. So typically in a situation like this, so specific to a grazing permit, this is where the could come into place, is as you go through what they call a standards and guidelines, and for some reason, it may not meet standards and guidelines. And associated with that, then it comes in the duty of the federal government to make corrective actions. Oftentimes in those management plans, you just work with the permittees and agree that this is what we're going to do going forward. So it could require the following under a scenario like that through that planning process. I don't know if that still answers the question. Madam Chairman, I think the answer is I don't think it hurts anything.
All right. And so do you want to put that in the form of an amendment, Representative Storm?
I'd like to move an amendment that takes out or could require and replaces it with or indicates it may require. So that it requires some kind of action on the federal government to suggest that it's moving in that direction rather than.
Madam Chairman, I think that's probably a good amendment.
Okay. So moved by Representative Storr, seconded by Representative Larson. So did everybody get that? So on page 4, line 10, after requires, delete or could require, and insert or indicates it may require. Any discussion about that amendment?
Indicates it may require.
Question?
Question being called. All those in favor say aye.
Aye.
Opposed, no. Okay, so that amendment is adopted. Then moving on to page 5, there was a suggested amendment from Farm Bureau on page 5, after line 22. I believe, Mr. Hamilton, if you want to make sure that this is what you suggested. No reintroduction efforts shall occur until federal legislation brings in, oh, maybe I didn't take good notes, brings into conformance with 11-19-604. Is that, did you get that? Okay. Okay. Any discussion about that? Anybody want to move it? Apparently not. Okay. So we will not be adopting that amendment at this time. I think that's the end of the amendments at this time, so I don't know that we need to go through the bill. I think that we've been through it. So I guess we will roll call.
Representative Angelos?
Aye.
Representative Burkhart? Representative Byron?
Aye.
Representative Larson?
Aye.
Representative Singh?
Aye.
Representative Storer?
Aye.
Vice Chairman Western?
Aye.
Representative Winter?
Aye.
Chairwoman Newsom?
Aye.
9 ayes.
Okay, thank you.
Thank you, Madam Chairman, members of the committee.
We will move on to Senate File 109. Senator Beitman. Okay. Oh, you have that. Okay, great. Thanks, Tim. Senator Beitman, welcome to the House.
Well, thank you, Madam Chairwoman. Members of the committee, Senator Beitman representing Senate District 21 in Sheridan County. I bring to you today Senate File 109, Prohibit Red Flag Gun Seizure Act. This is probably not as controversial as your sheep bill, but this is a good due process bill. It does mention guns, but the majority of the bill is about protecting due process. Sorry, I'm getting a little feedback here. Let's put that back here. This passed the Senate 31-0. It's a unanimous vote. It's basically a common sense bill that says, you know, you cannot have your guns, firearms, or ammunition or accessories seized without due process, without your day in court, and without an adjudication from a judge. It's very important. So go ahead and flip over to page 2. What we're doing here, you'll see, in order to enforce this, we have to go in and amend the Governmental Claims Act. So you'll see that Title I, Section 39, Chapter 39, this just changes the language to allow a cause of action. So a governmental entity is liable for damages resulting from violating this act. This act, as you will see, is in Title IX, Administration of Government. It's going to be called the Prohibit Red Flag Gun Seizure Act. It goes on the bottom of page 2 with our Declaration of Authority. You see that a lot with our, protecting our rights types of bills. This is no different. We have our Second and 10th Amendment rights to the United States Constitution, Article 1, Section 24 of the Wyoming Constitution. Flip over to page 3, our sovereignty. We referenced the Prince case versus the United States. That was a Supreme Court case that upheld the anti-commandeering doctrine. The feds can't commandeer states to do their bidding for them, and also the dual sovereignty that we just talked about with our previous finding. And then we keep going down with findings. You can read those. The meat of the bill is on page 4. We're going to create Title IX, Chapter 14, Section 303, prohibiting red flag gun seizures and preempting local law. Subsection A, we define what a red flag gun seizure means. It means a federal statute, rule, executive order, judicial finding, or any state statute, rule, executive order, judicial finding that does any of the following. Prohibits specific person from owning, possessing, transporting, transferring, or receiving a firearm, ammunition, or related accessories unless the person has been convicted of a violent felony crime, is subject to an order of protection prohibiting firearms pursuant. And these citings are temporary domestic violence orders and permanent protection orders. So those are those statutes that we're talking about here. Or a substantially similar law of another jurisdiction in another state, or order not to possess a firearm, ammunition, or related accessories as a condition of bond. These are some important, you've probably seen this bill before. I think it's probably the third time we've tried it. We've learned a lot of our mistakes going forward. These are additions that were excluded from the last bill. It's in this bill now, so it makes this bill even better. Continuing on, B says orders the removal or requires their surrender of a firearm, ammunition, or related accessories from a specific person unless that person has been convicted of a violent felony crime, and then again goes on to the same statute references. We define violent felony. Moving on to the bottom of page 5. State of Wyoming, including any agency or political subdivision in the state, shall be prohibited from implementing or enforcing any federal statute, rule, or executive order, judicial order, or judicial finding of any, over to page 6, state statute, rule that would enforce a red flag gun seizure. Then we go on to talk about use of federal funds. This is the anti-commandeering language, accepting that the federal bribery money is what I call it. They'll send the money out to the states and try to get the states to, on the condition of accepting this money, you have to enforce these red flag laws. This prohibits that. Going to preemption at the bottom of page 6. Subsection E, I would like to turn your attention to that at the top of page 7. Subsection E is important. Nothing in this act shall be construed to prohibit or prevent a firearm, firearm accessory, or ammunition from being seized as evidence or collected by law enforcement in the course of a lawful investigation. It's a big carve out there. It's important for our law enforcement to be able to do their job, and we've worked with, in the Senate hearing, we worked with the Sheriffs and Chiefs Association to get an amendment. It was a friendly amendment to add the word "or collected" there at in that paragraph, because sometimes they find firearms just sitting on the side of the road, or people will bring them to them, and that was a friendly amendment. So that's why this is the engrossed version, and that's why that's in there. So then we go into the civil actions. So if you were aggrieved and you had your rights taken away by a governmental entity, this gives you standing to take civil action against the agency, not the officer. And let me repeat that. Previous iterations of this bill have kind of pierced that qualified immunity of the officer, and we've seen some bills that go after criminal penalties. This does not do that. This just allows the citizen to take action against the agency involved, not the officer involved. So big difference from bills passed. That repealer is on page 10, deals with non-violent felons being able to have their rights restored or possessing a firearm. So current law, if you are a white-collar criminal and you've done your time, non-violent criminal, you still, under current law, if you were caught possessing a firearm or were hunting, it's a misdemeanor in current law. It never got fixed. So this takes care of that. 68102C deals with that. And this act is effective immediately. Madam Chairwoman, that is your bill. And I'll stand for any questions.
Thank you. Questions, Representative Larson?
Thank you, Madam Chairwoman. Senator, so on page 7, where it lines out the $50,000, how did you derive that number? Is that common among other states? Where'd you get that from?
Senator Whiteman?
Thank you, Representative. Yes, Madam Chairman, I believe that is common throughout our statutes with regard to this, and especially I believe in Title IX with the SEPA law that was passed last year. I think that number mirrors that, but I can check on you for sure and get you that information.
Any other questions for the senator? No? Okay, I guess we'll open it to agency. Director Nesvik.
Good morning, Madam Chair. Brian Nesvik, Director of Wyoming Game and Fish Department. So Chief Game Warden's been working on this bill and has worked up the amendment that I think you've had the opportunity to see. We have one very small concern that I think is addressed by the amendments that the chief will talk about. And so I will turn this over to Chief King.
Great. Chief King, can you introduce yourself?
Madam Chairwoman, members of the committee, my name is Rick King. I'm Chief Game Warden with the Wyoming Game and Fish Department. And, this certainly, our concern has been that there's a little bit of ambiguity between this bill and a statute that's in Title 23. In Title 23, the department has the ability to seize and then through a forfeiture process, take a firearm for a commission of a serious wildlife crime. So we have two really egregious crimes that if you're convicted of that, then you could be subject to a seizure of your firearm and then forfeiture through a court order. And so in reviewing this, it looks like there's just not clarity between those two. And our biggest concern is that there's a civil penalty attached with this that could be imposed on the agency if we do something that's in violation of this statute. And so we would simply just seek a simple, clear exception to the conflict in 23.6.208. So if 23.6.208 is just included in the exception list, it'll be clear that there is no conflict and 23.6.208 can continue on.
So the committee, you have in front of you a proposed amendment. And in talking with the Game and Fish and in talking with the sheriffs and chief of police organization, we just kind of lumped all of these exception requests into one kind of item. And so the request from Game and Fish is the last sentence of, is subject to an order to seize a firearm, ammunition, or related accessories under Wyoming statute 23.6.208 is the last sentence of that. And we'll talk about the first sentences with the sheriffs and chief of police. Representative Western.
Thank you, Madam Chairwoman. Chief Warden King, so you said, serious crime. Could you maybe, I guess, the first part of my question is, are those crimes misdemeanors or are they felonies? And two, maybe kind of give me an example of what those crimes might be in a scenario that your department has encountered before.
Chief King.
Madam Chairwoman, Representative Western, so there's two specific statutes that 23.6.208 applies to. Those would be wanton destruction and then take out a season and without a license. We often refer to that as the winter range statute. So an example would be if somebody rolls out onto the winter range in December or January and poaches a large trophy mule deer buck, we would charge them under 102D, that winter range statute. And then if convicted, then potentially the firearm that was used in that crime could be seized and then forfeited under 23.6.208. Those are misdemeanors. They only rise to the level of a felony on a third or subsequent conviction, but they are individually, they're as is all game and fish violations, just misdemeanors.
Follow up. Any other questions for Game and Fish? Okay, great, thanks. Then if we could move to sheriffs and chief of police. So if you'd please introduce yourself.
Madam Chair, my name is Alan Thompson. I'm the Executive Director of the Wyoming Association of Sheriffs and Chiefs of Police. We appreciate the opportunity from the good senator from Sheridan County to amend the language in the exception on page 7. But since that time in the other house across the hall, or the other committee across the hall, we've had some concepts brought to our attention that, in addition to the concerns about Title 25, and if there's a circumstance that we need to secure a firearm related to that, and then parole or probation conditions in addition to those bond conditions. So those conversations, along with Game and Fish concerns, helped us put together an amendment that hopefully encapsulates all of that. And if I could, Madam Chair, just go through the amendment itself. Sure. So the first recommendation is on page 4, line 22. To delete the or and add a comma there. So then on the next page, page 5, line 2, after the word bond, might suggest inserting language such as parole or probation. So that would read bond, parole, probation. comma, is subject to an order of involuntary hospitalization under Wyoming State Statute 2510-110, or is subject to an order to seize a firearm, ammunition, or related accessory under Wyoming Statute 23-6208, which is the game and fish statute that we just, and then also on page 5, line 10, similar language there, delete the or and insert a comma, so that on page 5, line 12, after bond, inserting that same language that comports with the paragraph above.
Thank
And
you.
Madam Chair, any questions, I'd be happy to answer.
Did you have any other comments besides the amendment, or are you good?
No, I think we're good, Madam Chair, thank
Okay,
you.
question, Representative Western.
Thank you, Madam Chairwoman. Ms. Thompson, so just to make sure we'll walk me through the scenario here. Title 25, we're talking about a scenario, it's not someone who might perhaps be a persuasion that is not friendly to the Second Amendment. Rather, we're talking about a situation where someone who has, say, schizophrenia, something that is diagnosable in the DSM-5, that type of scenario. Is that the kind of thing that we're talking about here?
Mr. Thompson.
Yeah, so Madam Chair, to answer the good representative's question, there are just unknown scenarios that might be coming from court orders based on existing law where they've had due process. And, I haven't personally been in a position over 25 years where I've been in that direct position to seize a firearm from someone that was subject to a Title 25 hold, other than we might have held on to it because it was in a car or out on the, a house that we couldn't secure and gave back to the person in a few days, but as far as seizing that firearm, preventing them from having it, I don't know what that would look like other than court orders as an outcome from a Title 25 hearing that does oftentimes mandate things like continue with treatment, continue with medication, continue with, and I could imagine it could say things like prohibited from owning firearms, especially if a firearm was possibly threatened to be used in a Title 25 type of case leading up to that. And keep in mind, Madam Chair, Title 25 is not a criminal violation of law. So that's where law enforcement wants to be in a position where they clearly understand their expectations from this new law so that they avoid any penalties that might come from inadvertently or mistake of fact violating that going forward. So we just want to make sure that we're absolutely clear on what our lane is going forward and making sure that we can comply with the law.
Follow up? Any other questions? Okay, thank you, Mr. Thompson. Any other public comment? Hi, so if you'd introduce yourself, that'd be great.
Madam Chair, thank you. My name is Mark Jones. I'm a national director with Gun Owners of America. We represent about 3 million Americans. I live in Johnson County, Wyoming. In 2022, the Biden administration made millions of dollars available to the states to implement red flag gun confiscation orders. To my knowledge, Wyoming has not taken that money. But this is a very important piece of legislation. Red flag gun confiscation orders violate at least 4 of the amendments to the U.S. Constitution. They violate your Second Amendment rights to keep and bear arms, your Fourth Amendment rights not to be subject to unreasonable search and seizures, your Fifth Amendment rights to go before a grand jury, and your 14th Amendment rights to due process. So we certainly support the concepts in this bill. I want to point out that under Wyoming law, or law of any state, there are 2 main ways for a citizen to seek relief when they're aggrieved, and one is civil and the other is criminal. This bill has a civil penalty, which is excellent, but I should point out that in 2022, Wyoming passed the Second Amendment Protection Act, and it made a criminal offense out of the unconstitutional enforcement of federal gun control. Now, a citizen in Wyoming who's aggrieved under any of these types of statutes that only has a criminal civil penalty would be forced to hire their own attorney, go in front of appointed judges to seek relief. And we're okay with that. By having the criminal path available, the county prosecutors are also on the hook to enforce the law. I believe it's important to make it clear in this proposed legislation that violations of this legislation are already a violation of Wyoming statutes. Wyoming Statute 9-14-203, passed 2 years ago, commonly referred to as SAPA, makes it illegal to do this type of thing. And there's a criminal penalty in our statutes now. So I believe that it would be important on page 7, line 7, to insert a reference to the Wyoming Second Amendment Protection Act, Statute 9-14-203, to make it clear that this is also a criminal violation. I will point out that when the SAPA law passed 2 years ago, it was widely supported by law enforcement. There was a press conference right here in this Capitol with representatives from the House, the Senate, dozens of police officers, so they supported that concept, along with our organization, Gun Owners of America. That was designed to protect the rights of Wyoming citizens from overreaching federal government, which is what we're all here to do, today to do. So I believe it's very important for you to consider on page 7, line 7, making it clear that this legislation also comes with a criminal penalty. Remember, and this is important for the people of Wyoming to remember, if you're aggrieved and you have to go to a civil process, you got to hire your own attorney. The criminal process is also very important.
Thank you.
Thank you, Madam Chairwoman. I'd stand for any questions.
Thank you. Any questions for Mr. Jones? No? Thank you. Anyone else? Ms. Johnson.
Madam Chair, members of the committee, Jess Johnson, Wyoming Wildlife Federation, and I'll just keep this very brief. I just wanted to make sure that we emphasize how important that addition for the game and fish exemption was for us, and the way that we're looking at how we handle wildlife crime and everything. That part is really, really important that we get right and make sure that we have them included in that exemption. So just stand for any questions.
Thank you. Any questions for Ms. Johnson? No. Thank you.
Thank you.
Any other? All right, please introduce yourself.
Yep. Good afternoon, Madam Chairwoman, members of the committee. Mark Moody, just a regular citizen here in Laramie County. I support this bill 100%. We know that red flag laws do violate the Amendment 5 of the U.S. Constitution and Article 1, Section 6 of the Wyoming Constitution, which guarantees us due process. And lastly, I'll just say real quickly, it's good that it prohibits the state of Wyoming from taking federal funds to enforce this unconstitutional red flag aspect. Both our federal delegation, Senator Barrasso and Senator Lummis, voted against it. And we know Congresswoman Hageman also would have voted against it too, but it happened in 2022 in the summer. And I'll stand for questions.
Thank you. Any questions? No. Thank you so much.
Thank you.
Ms. Weber.
Good afternoon, Chairman Newsom and committee members. My name is Nina Weber. I'm an avid hunter and outdoorsman. I am in favor of Senate File 109 and urge your aye vote to prohibit red flag gun seizure. Red flag gun seizure is a real issue in Wyoming. Here's what happened to me during a routine elk hunt in 2022. I was falsely accused by a person who opposes my political views, and I was politically attacked using red flag and lawfare. Out of 8 hunters, it was alleged my bullets whizzed by on the next ranch. I did not do this. I was selected for the ticket. During my first court appearance and my plea of not guilty, the prosecutor attempted to take away my hunting rifles without due process and based only on hearsay. My attorney had to fight to keep my hunting rifles in my locked safe. During this appearance, the judge said I would be able to open carry and conceal carry any of my handguns, as well as use any of my shotguns. A few months later, the prosecutor dismissed my case with prejudice, as I did not do this and there was no evidence. This red flag lawfare was very expensive, and I was judged unfairly by the press before any evidence was presented. This attack was politically motivated. Chairman Newsom and committee members, red flag is currently being used in our state. I was targeted for my political beliefs, and I urge an aye vote to pass this much-needed bill. I wouldn't want anybody else in our state to go through what I went through. I would stand for any questions. Thank you.
Any questions for Ms. Weber? No, thank you.
Thank you.
Anyone else want to talk about this topic? Okay. Looks like we will, oh, hands raised online. Okay. Mr. Dorr.
Can you hear me?
Yes, go ahead and introduce yourself. You have 3
Thank you,
minutes.
Madam Chair. My name is Aaron Dorr. I'm here on behalf of the members of Wyoming gun owners in support of SF 109 as written. As you've already heard from other testimony, red flag laws allow a gun owner to have their rights suspended and their guns seized before any conviction of a crime in a court of law. Furthermore, they shred the due process rights because a lot of times these hearings happen in ex parte hearings where you hear about it afterwards if you are the gun owner in question. So SF 109 is designed to prevent that from happening to our members here in Wyoming by requiring a felony violent crime conviction or other judicial orders before a person's guns could be seized. Too often we've seen gun owners in other states that have red flag laws be targeted by maybe it's a bitter ex-spouse, or maybe it's somebody who's angry at you for a promotion at work, and they can effectively disrupt your entire life by a mere allegation that you hear about after the fact. SF 109 is designed to prevent that from happening by requiring that conviction. There's been a lot of talk about the penalty section in this bill. It's found on page 7. Our members believe that civil penalties are the appropriate response to a red flag infraction. We disagreed with the criminal penalties in the section of the law that was passed 2 years ago because our members are support law enforcement, and they believe that most times when these orders are given to be followed, they're done so by department heads, oftentimes who are political appointees, where the frontline officers reject gun control and red flag laws in particular. So we are big supporters of the current penalties as written, the civil penalties. Again, the bill did pass the Senate 31-0, and we'd urge you guys to advance this bill as written. Thank you.
Any questions for Mr. Dorr? No, thank you for your
Thank you.
testimony. Anyone else online? No? Okay. I think we will close public testimony at this point. What's the desire of the committee?
Bill?
Move the bill. Moved by Representative Larson, seconded by Representative Western. I guess we can go through the bill page by page. Any changes on page 1? Any changes on page 2? Any changes on page 3? Any changes on page 4?
Madam Chairwoman?
Representative Larson.
So at this time, I'll just move your proposed amendment. So it's more than just page 4, but as presented, it's page 4, line 22, delete or and insert comma, page 5, line 2, after bond, insert comma, parole or probation, comma, is subject to an order of involuntary hospitalization under Wyoming statute 2510-110, or is subject to an order to seize a firearm, comma, ammunition, or related accessories under Wyoming statute 23-6-208, and similar language on page 5, line 10, and page 5, line 12.
Okay, a second. I'll second it. Any discussion on the amendment? All those in favor say aye.
Aye.
Opposed, no? No. That passes, so that'll go forward. Then moving on, I guess we talked about page 4, page 5. Any amendments on page 6? Any amendments on page 7? I guess there was a suggestion on page 7. And I guess it was to just add in there the reference to 914-203. Okay. Okay, so I don't know what that, I guess after Senator Beitman, if you could help me with this, that'd be terrific. So would it be at the end of,
I don't know
A?
where, I mean, you could just do a conceptual amendment if that is the will of the committee. I mean, I would prefer to leave it out.
Okay.
But obviously, it's in your hands now.
Okay.
But yeah, you could do a statutory reference to the SAPA bill there at 914-203 somewhere, and
Okay.
LSO could probably feather that
But
in for you.
it really in no way changes the intent of the statute. It just references current civil penalty, as
So
I understand.
in 914-304, Madam Chairman, it does discuss civil actions permitted and remedies. You would have to change that. If you were to add criminal penalties, you'd need to change that title.
Okay.
And then add in somehow the criminal penalties.
So as the sponsor of the bill,
I would prefer not to add criminal penalties. I think it may be seen as anti-law enforcement, and we're certainly not anti-law enforcement. I think also, dealing with getting a prosecutor, a local DA to prosecute a local cop, probably not gonna happen. So I think you're adding it in there, but I don't ever see that ever happening. I think the most logical course of action would be to take a civil action and get an injunction from a judge to establish due process.
okay,
But it's your discretion.
okay. What's the feeling of the committee?
Just leave it as.
Leave it as is, okay. Moving on then to page 8. Any changes there? Moving on to page 9. And moving on to page 10 with the repealer, and then effective immediately. Any changes there? Okay, question on the bill. You want to call a roll?
Representative Angelos?
Aye.
Representative Burkhart by absentee, aye.
Okay.
Representative Byron?
Aye.
Representative Larson?
Aye.
Representative Singh?
Aye.
Representative Storer by absentee, no. Vice Chairman Western?
Aye.
Representative Winter?
Aye.
Madam Chairwoman Newsom?
Aye,
8 aye, 1 no.
thank you. Okay, thank you, Senator Beitman. I think Representative Haroldson, I think he was here, or you'll find somebody to floor manage it for you? Okay. Okay, when I talked with him the other day about it, he kind of volunteered, so if you want to get with him, that'd be great. Thank you, Senator.
Chairwoman Newsom, so the 301, we didn't do anything with
Well,
that,
no,
correct?
that wasn't
Okay,
brought.
just verifying,
Okay.
thank you.
That's right. Abby? Okay. So moving on to Senate File 111, mule and whitetail deer separate hunting seasons. Did Senator Driscoll have to leave us? Oh, no, there he is. Okay. So because we have a bill after this, we'll keep that same timing. So if you want to, Ogden, go over your bill and our Senator.
Madam
Driscoll-
Chairman, I'm going to be pretty quick with it.
All right.
Committee, thank you very much. We've all had lots of comments on it and lots of misinformation, so I'll just kind of go with the bill and address a few of those and go to questions.
Great.
This bill's come back and forth through the years, and it ended up being one of the topics of the Wildlife Task Force sitting here with Director Nesvik. Was extensively debated and talked about what it could and couldn't do. and what it should and shouldn't do. And so it came out as a recommendation of the task force to actually come with this bill, and it never did come. So what this bill does, it's kind of lengthy, but it only does one thing. It differentiates what are two different species, the only thing that's ever been in game and fish statute. Mule deer and white-tailed deer are no closer related than antelope and mule deer are. They're different species, they're different, and they should be managed differently. And so for much of the state, they do manage them separately. You've got a dry area for mule deer or other. In the Black Hills where I live, they've been lumped together. Makes it hard to do herd objectives and actually reach it on the other end of it. So all this does is does the two separate species, runs through it. It has an amendment on it, and that is for licenses for special hunts. We worked with the Game and Fish and the director to decide what species it was and how it went. That's the amendment that's on the bill, which is the 25. The other amendment we made was with consultation with Game and Fish. We moved the effective date to July of 2026 to give them some time to do it. Addressing some of the questions that are out there, and I'm just gonna get ahead of them a little because there's a lot of misinformation, that this is gonna cause a big influx of hunters and that overrun the Black Hills or different areas. The fact of the matter is, Black Hills has been a draw area for the last at least 40 years. Licenses are set this year, director can tell you, but I believe they're less than 2,000 non-resident licenses. Region A is a general deal. It's already unlimited. Any hunter from the state of Wyoming who wants to buy a Region A general permit can come buy it. The only difference under this would be is I would guess likely that mule deer would be a draw area as they tried to grow the mule deer herd. Whitetail would probably still be a general area, and you'd be able to come shoot all you want. We kind of do whatever. I believe we're supported by the Game and Fish. Outfitters and guides support it. As you all know, mule deer, it's been a big topic. They're in decline statewide. The one area that kind of wasn't declining up till a few years ago was the Black Hills area, and all of a sudden now, as our whitetail numbers have plummeted because of AHD and blue tongue, we're now putting unbelievable pressures on our mule deer herds, particularly our young bucks. These guys in the past would take a whitetail, take some meat home, go shoot a small whitetail buck. Now they'll take the first buck they find on these any deer tags. And so the outfitters are telling me that we're just decimating our mule deer herds. And 3-4 years ago, they were opposed to it. I've got outfitters coming to me now saying this is kind of a necessary evil. We need to do it. Game and Fish will testify behind me. They've got the ability to continue to do almost everything exactly like it is. It just kind of splits these apart and gives them more tools in their chest. And I'll drop it at that and go on to further testimony.
Any questions for President Driscoll? Director Nesvik.
Madam Chair, members of the committee, I really don't have a lot to add to what the president brought up as far as what this bill does. There's nothing in this bill that the department can't work with, and there's some adjustments that would be required, not necessarily bad adjustments, but adjustments that would have to be made logistically. For example, right now there's non-resident hunters that have deer preference points, so we'll have to figure out how to deal with deer preference points if there's a white-tailed deer license and a mule deer license. I was on the task force and I voted to support this. Very pragmatically, very simple-minded. Mule deer are a completely different species than white-tailed deer, and they're the only two species that were managed on one license. As far as big and trophy game, we do have some birds and small game that are managed on the same license, but there's no other big game that aren't. So I think that's probably all I need to say on this, Madam Chair. I'd be glad to answer questions, though.
Any questions for the director? Maybe we need to change the term deer to something else. Like, I remember reading a Mark Twain of, we should not have named prairie dogs, we should have named them prairie rats. And then we would not have an affinity for them. But that aside, any other questions from the, okay, then I guess we'll start with public testimony. So anybody that would like to testify, please come up. Anybody online? No? Okay, so we'll move it back to the committee. We'll close public testimony. moving the bill to the committee. What's the pleasure of the committee? Move the bill by Representative Byron. Seconded by Representative Larson. Do you want to go through the bill page by page, or is everybody comfortable with it? I had one question that was asked to me by somebody, would making the whitetail license less expensive promote more hunting of whitetail deer?
Madam Chair, right now we use the reduced price Dauphin license to really, that's where we really are able to manage whitetail deer. And those licenses are already reduced. My recommendation would be that the price point that the legislature sets, which is for full price licenses, remain the same for both species.
Okay, thank you. Representative Angeles.
Thank you so much. My curiosity is, do you see that, mule deer will be, back feed, that the quotas will be lower? Do you think that that's one way that you'll help?
Yeah, Madam Chair, Representative Angelos, that's actually one of the ways the department and the commission have to, when we have a stated goal, like for example, to grow more mule deer, doing limited quota or having a lower quota in an already limited quota area is one way. Season length is another way we control harvest. So those options are they're actually on the table now, but we would still be able to do that under this as well.
Madam Chairman, a
Mr.
little bit of
President.
follow-up.
Yep.
Yeah, they may end up even looking at changing some areas. Region A general's huge. It's 1 through 6, runs roughly from south of Newcastle all the way to the Montana border. And so big parts of it are mule deer only with just limited whitetails. And then your irrigated cropland areas tend to be really heavy to whitetails and really light to mule deer. And so what we're really trying to do is give them another tool in the box so we can grow some of these herds the way they want to. I really want them to meet herd objectives, and we want to keep mule deer healthy. And that's going to require some footwork on their part, because we really do not want to injure these folks that live on mule deer hunting, and the mule deer are thriving, because good parts of Region A really does have good, healthy mule deer populations.
Okay, any other questions? All right, I guess we will.
I just have a comment on the bill,
Okay.
if appropriate. Yeah, I'm, in looking at the bill and getting a fair amount of emails about it, we feel left out a little bit on the west edge of the state that is certainly suffering from what happened last year. And as an avid deer hunter and someone that spent some time out there this year, I saw far more whitetail than I did mule deer. So I appreciate the good bringer and always worried about his country, but this bill really helps, I think, in places that I talked to a lot of longtime locals and say, why are you even hunting whitetail in Teton County? There are none, but they've become a major issue, and I really appreciate this, the direction this is going.
Any other comments from the committee? Okay, I think we're good. I think we will go ahead and vote. Oh, yes, absolutely.
I
Representative
do
Angelos.
recognize that the mule deer populations have dropped, and we need to do something. I'm going to pass this out of committee, but I'm still unsure if I'll pass it on the floor, but I will pass it out of committee, so I'm an aye.
Thank you for that heads up. I really appreciate it. Okay, so I think we'll just call the roll, Barb, and carry on.
Representative Angelos.
Aye.
Representative Burkhart, absentee, aye. Representative Byron.
Aye.
Representative Larson.
Aye.
Representative Singh.
Aye.
Representative Storer.
Aye.
Vice Chairman Western. Representative Winter.
Aye.
Chairwoman Newsom.
Aye.
9 aye.
Okay, so you have. Okay, so I'm assuming you have somebody to floor manage that, Mr. President? All right, I'm assuming you'll assign somebody to floor manage this for us. Okay, all right. I guess it's you. Or JT could do. All right, we'll move on to Senate File 72. I do not see Senator Case in the room, so I'm hoping our good friends from Public Service Commission who have sat through this fine meeting will give us some insight. Welcome. I'm not used to seeing you guys here. I'm used to seeing you guys in corporations. So I guess whatever order you want to go or however you want this to roll, just asking that you introduce yourselves. Thank you.
Madam Chairwoman, Chris Petrie. I'm Deputy Chairman at the Wyoming Public Service Commission. Commissioner Robinson is with me, and our Chief Counsel, John Burbridge. As you mentioned, we have heard all about this bill elsewhere, and I think I can explain it a bit if that's your wish.
That would be great. Thank you.
Okay. This bill instructs the Public Service Commission, while it's setting rates, to implicitly, at least, identify and then prohibit the rate recovery of costs associated or resulting from voluntary donations by utilities. And so that perhaps could be a little bit mysterious, but what this is directed at, as I understand it, is one program that exists right now that involves customers purchasing renewable energy credits from the utility. If there is money left over once the utility satisfies their obligation to purchase for those volunteering customers the renewable credits. So if they obtain the credits for less than the customer paid, then that leftover money is distributed through grants or donations to projects proposed by other customers that are generally directed towards the installation of net metering or customer generation facilities. And there has been a sort of an ongoing concern that net metering installations may cause what you might think of as a regressive cross-subsidy. That is, customers who obtain these installations to generate their own power, in some cases are avoiding a portion of the fixed cost that the utility experiences. That's because there's a fixed cost component in the volumetric rates. So basically it means that if the monthly charge is not sufficient to recover the utility's fixed costs, then the volumetric rate makes up for that as the customer consumes a portion of each incremental charge is ultimately devoted to the fixed costs that the utility has incurred. So this would require us, the Public Service Commission, to identify those cases where the public utilities donation to a customer's construction of a net metering facility is causing costs that are implicit or that ultimately have to be paid by somebody, and this would prohibit the utility from collecting those from recovering those costs through the rates that all customers are paying. And we understand it, and in spite of that sort of lengthy intro, this is a relatively straightforward rate-making matter, and I think we understand it, and I don't see any implementation issues with this.
Any questions? Representative Storr.
Thank you, Madam Chairwoman. Can you tell me how much net metering is going on in the state of Wyoming as a percentage of electricity produced currently?
Go ahead.
Madam Chairman, Representative Storr, I don't have a precise response for that. It varies by utility. There are areas in the state where there is a higher net metering penetration. But the last information I had is that it's in the low single-digit percentages.
Thank you.
Follow-up, Representative? Okay. Any other questions? Okay, I have one. Could you give us kind of a step-by-step example of how this might work? So if I have wind or solar at my house, the utility, I'm trying to get clear, the kind of the, maybe not a timeline, but how does the money flow?
Madam Chairwoman, are you asking about an instance where a utility donation would be involved?
Yes.
Okay, and then, thank you. So perhaps to clarify off the bat a little bit, I believe that what we're talking about here, the utility donations, have been given to organizations. And so you're going to see nonprofits or perhaps, and I do know of some governmental entities that have received a grant. And I believe that what has generally happened is that the utility has covered approximately half the cost of a fairly large net metering installation. So I always figure that a residential net meterer is right sizing their system at about 5 kilowatts, 5,000 watts. The statutory cap on the size of a net metering installation is 25. So roughly 5 times what a residential customer would typically need to cover their energy consumption. And so these are among the larger net metering installations. So the Rocky Mountain Power lists the awards and describes the projects, and it appears that they're generally right up against the 25 kW limit. And so the idea here is that if the utility, by award of a grant, encourages, causes, subsidizes this installation, and then that customer does not end up paying its fair share of fixed costs, then those would be the costs that are prohibited from being collected by the utility here. So the utility would be barred from recovering costs that are associated with the operation of a facility like this. And as I understand it, it wouldn't impact that customer or other customers, except to the extent that it protected them from being the ones who would pay the shortfall resulting from the operation of the net metering facility. So the commission would look at this in rate proceedings, and if such costs were identified, then the utility would not be allowed to recover them from the general body of customers. If no such costs were identified, then it would have no effect. There would be no problem to solve, so to speak.
Thank you. Any other questions? Representative Storr.
Thank you, Madam Chairwoman. Thank you for that explanation, very helpful. Do we have any sense of what percentage of total costs for running the utility this might represent?
Mr. Petrie.
Madam Chairwoman, Representative Storr, in the grand scheme of the costs incurred by a utility providing service, this is not large. For one thing, there are not a tremendously large amount of net metering customers. So there's that. And then this depends on the performance of the net metering installation. The better it performs, logically, the more cost might be avoided by the customer and transmitted, so transmitted is not really the right word, but transmitted to other customers through rates. And so, you know, I really can't even take a stab at a percentage of overall costs or customers' bills. It was not immaterial what was presented 2 or 3 years ago by the Office of Consumer Advocate when they looked into residential net metering results, as in whether or not net metering customers were avoiding making their appropriate contribution to fixed costs. This really all in a way ties back to a prohibition that is in the net metering statutes to the imposition of any special charges for net metering customers. So that's not allowed. So that rate making tool is not available to the commission. And so this is intended to address that. As I said, they weren't immaterial costs, but it depends on how many net meters there are and how successful they are, how much they.
Follow up.
That'd be fine.
Thank you, Madam Chairwoman. What will it cost for you to implement, to be able to do this, I guess?
Mr. Petrie?
Madam Chairwoman, Representative Storer, this is an exercise that I believe the commission could conduct without any additional cost. It would be a relatively simple affair. I believe that in the one program that we know involves contributions of this sort, voluntary contributions by the utility, I believe there's something like 2 or 3 dozen instances that I'm sure the utility can readily identify, and I think that the commission could very, very easily calculate what those costs were, and you'd remove them then from the utility's revenue requirement that the commission would allow.
Any other questions? Oh, okay. Any other comments from the Public Service Commission? No, thank you. Anyone else want to comment on this? So we have about 15 minutes left till we need to be back, so we'll impose those 3-minute rules. Ms. Serrano.
Thank you. Madam Chairman, members of the committee, I have some answers to some of the questions that were asked before I dive in.
Can you introduce yourself?
Oh, sorry, thank you. Era Arano, Wyoming Outdoor Council. The question that was asked in terms of the percentage of net metered systems, the 2021 number we have is 0.6% in the residential class, so it's safe to say less than 1% there. And the studies that we did, and I believe we shared one with you last year at this time, show that the cost shift isn't realized until you get much closer to 10%. The systems additionally that we're talking about here with the Blue Sky program are not usually in the residential rate class. They're in the small service or general service categories, which has a very different rate setup, which I will discuss shortly. And about the note regarding the size of the systems, I am a member of the Lander Care and Share Food Bank, and we were so separately, taking this off for just a moment, recently a recipient of that grant, and with the energy needed for our refrigerators and our freezers to provide good quality food to our clients, we do not cover our full electric bill with the system that has been installed. So back to the Wyoming Outdoor Council. Thinking about the Blue Sky program that covers the capital costs of installing these projects, places that have benefited in addition to the Lander Care and Share Food Bank are the Natrona County Meals on Wheels, Lander Senior Center, Riverton Community Entry Services, Laramie Downtown Clinic, the Eastern Shoshone Boys and Girls Club, and by saving on electricity costs, these organizations are able to invest that money back into their communities with great benefit. No costs from this program, as you heard, are included in Rocky Mountain's base rates, and administration costs for the program are also recovered through the donated tariffs and not included in the rates. And that's made clear through the controlling document for the program, which I would be happy to provide for you if you would like. Speaking of the rates, the Blue Sky projects are not built on residential meters, as I'd mentioned. They're built on either small general service or general service meters that offset the energy costs at well below the residential rates. And so the costs in those two classes are 6 cents per kilowatt hour and 3 cents per kilowatt hour, which is much less than residential. That rate of 6 or 3 cents is very close to the bulk or avoided cost for the electricity. And so Blue Sky grantees really aren't, the numbers are even smaller than if we were arguing in the residential class. And the Blue Sky grantees still pay for fixed costs and demand charges, which are higher in those categories that I mentioned. Our hope is that Wyoming will continue to stay open to volunteer-based programs like the ones that are designed to help community groups save on their utility costs and invest in their communities. And with a small number of Blue Sky grantees, this cost shift is not an issue. Thank you. I'll stand for questions.
Any questions? No, thank you.
Thank you.
Doctor? Thank you for being our doctor of the day several times.
Thank you, Madam Chair. I thank you and the committee for allowing me to speak as a citizen Wyoming landowner.
Could you introduce yourself?
My name is Jason, physician here in Wyoming. I'm a landowner. I'm a ratepayer, and I am here to speak against Senate File 72. I'm asking you to end this bill. I want to make a point that I have a home here in Cheyenne, and I have 18 kilowatts rated renewable energy and 135 kilowatt hours of battery storage, and I still rely on the grid during the coldest months of the year. I'm a net metering customer, and I want to share real numbers rather than the imaginary, hypothetical, potential, maybe someday, if the tea leaves are right, type numbers that are being presented by the proponents of this bill. When I have a net surplus at the end of the year, I recover 1.6 cents per kilowatt hour for every unused banked kilowatt hour of electricity that has been stored in the prior year. That same electricity that I send out to the grid during the year is being sold between 3.7 and 14.2 cents per kilowatt hour. At no time is the utility making anything other than a profit off of the electricity I am providing without them having to pay for any installation or infrastructure. That profit, a small section of it, is used for charitable donations. They have scholarships. There's the program that you heard about helping nonprofits and governmental agencies get renewable energy. But anytime there's a surplus, it's happening mainly during daylight because that's when the sun is shining. It's also when the time of use rates are highest. So the utility is getting cheap electricity and selling it at a premium time at a premium profit. So this whole idea of cost shifting is nonsense. I am not being subsidized by any other ratepayers. I, in fact, am subsidizing them. And I don't mind doing so as long as we don't start carving out things that is unnecessarily overregulation that discourages investing in Wyoming, either in renewable energy or any other business. I will take your questions if you have any for me.
Any questions for Dr. Bloomberg? Okay, thank you. Do you want to come up? Hi, please introduce yourself.
Madam Chair, members of the committee, my name is Claire Duder and I'm with Powder River Basin Resource Council. I sent over a handout on Blue Sky program and all the benefits that comes with it. And I'll keep my comments short, but we urge you to vote no on this. This is another way to complicate and attack net metering. We've seen this in the past. Wyoming has a lot of support for net metering. And these grant recipients are still subject to the 25 kilowatt cap. They're not making a profit. They're just trying to save some money and help their community. And we just really urge you to vote no on this. Thank you.
Any questions? Thank you. Rick?
Good afternoon. I'll try and make my comments brief. I hope that you all got
Can
the
you
email
introduce,
I
can you
sent.
introduce yourself?
Dick Merklin, Wyoming Solar Coalition.
Mr. Merklin.
I sent a email to Speaker of the House Summers, and I'm sure that I sent every one of you a copy too. I hope that you received it and been able to read it. I concur with the previous speakers who oppose this bill. Wyoming Solar Coalition also stands in opposition. Not because of RMP's Blue Sky program and the good it is doing, it is working for those affected. SF 72 is a useless and non-essential bill. It should never have been brought up during the budget session, as far as I'm concerned. It has nothing to do with the budget. It affects my budget as a net meter customer or owner. All this bill is trying to do is to create a problem where none exists. Plain and simple, this is nothing more than a backdoor to decimate the net metering statutes that have been on the books in Wyoming since July of 2001. The senator who sponsored this bill brought the net metering up in the Senate Corporation Subcommittee hearing. And he was talking about net metering, no bones about it. This is nothing but a backdoor to let him get in and get net metering gone. I'm sure there are ways that the PSC that they can ensure that RMPs, Rocky Mountain Power's ratepayers, don't get gouged when they bring another rate increase to the PSC, where it would contain monies that had been earmarked as donations. Make them produce their books for an audit if they have another rate increase request. Same goes for Black Hills Energy or Montana Dakota Utility. To answer a question that was asked earlier, Wyoming's 43rd in this nation with regards to renewable energy resource projects. 43rd. Where we're at with the energy we have, we should be up in the top 10. We're not. Less than 1%, as was alluded to earlier, of Wyoming's total population have these renewable resource systems on their properties. We ask you to vote no. Maybe don't even bring it up for a vote and let it die like SF 92 did last session. Thank you.
Any question for Mr. Merklin? No, thank you. Mr. Kaysen.
Thank you, Madam Chairwoman, members of the committee. I'm Rick Kaysen with Rocky Mountain Power. It's kind of fun to hear folks talk about something positive with Rocky Mountain Power and the Blue Sky program. So yes, I believe this bill is initiated because of the Blue Sky program. So bear with me, I'm not going to plow the same ground, but just to reaffirm, any costs associated with that program are not base rate. They are totally separate. So with rate cases or anything in the future, you can let that, not worry about that, and it's not Rocky Mountain Power's attention to put that in rate base. It is totally voluntarily funded by other customers. We do have a tariff with the Public Service Commission has approved, but again, it is not base rate or anything of that nature. So the program has somewhat been alluded to, so I'm not going to go into any discussion about that. But for a couple of other points of topics or items that have been brought forward by previous speakers to Representative Storr's question, the percentage of net metering in the state. Less than 1%, that is correct. The concern here is that will it grow and how much will it grow? And if it does grow, then what would that subsidy or cost shifting grow to? Other states have not acted early, perhaps, in what is, and we've heard perceived, or is it real subsidization or cost shifting? States like California, Utah, it has grown very popular. And now their legislative bodies are addressing net metering because in those states they have found that the subsidization gap has grown. So again, that is a concern. Will it grow in Wyoming? You know, that's probably a pretty good thing. Rocky Mountain Power is not against net metering. Let's make that very, very clear. We are all about the all above energy strategy and looking at that portfolio and what's going to contribute to the grid. So, but we do have the concern for all of our customers is what that gap or that subsidization may grow to. It was mentioned earlier about the 25 kilowatt threshold. That is usually more towards the higher users on a commercial type of a basis. And you heard nonprofits and that type thing. So the Blue Sky program does not necessarily focus on residential customers. It's more at the higher users that can benefit that. And these are grants that are brought in voluntarily from other customers to pay for this program as well. I think it's important to understand that net metering does exist. As I mentioned, we do not oppose it. And with that, I'll try to answer any questions you may have.
Okay, any questions for Mr. Kaysen? Thank you.
One last, and
Sure.
I beg your indulgence, and I'm going to get slapped for this, but that's okay. Net metering has been around for a good number of years. It works. Perhaps net metering and the discussion about, and I think Cyrus Restaurant is looking at me like he knows where this is going. Maybe we should think about this being an interim topic along with a lot of other electricity interim topics that are probably going to come up and try to get a handle on this in concert with what the commission said about doing a study. Thank you for your indulgence.
You bet. So we are down to 4 minutes from having to be back in. So does anybody else want to talk? I think we've heard from everybody in the room nearly. I'll close public comment. What's the pleasure of the committee? Hearing no movement of the bill, I think Barb, what's the proper term? Do you know? Table? Well, we didn't have a
You didn't have
motion
a
at all.
first.
So we'll sort out the technicalities of that. Okay, I guess we are done. Thank you all. The bill is dead. What's that? Died in committee, yeah. Died lack of a motion. There we go. Thanks, Rick.